I'm actually a little nervous because I can usually jail people that are in front of me, and I can't do that with any of you, so bear with me. Can everyone hear me okay?
Yes.
Yeah? Great. All right. So first up, what I'm talking today about is the court responses, improving our court responses for people with lived experience of acquired brain injury. I'm a lawyer, so I don't know much, but I try to learn, and I've been on a journey of learning, and I've been very much assisted by some partnerships with some academics in this area, Dr. Gay Lansdell and Bernadette Saunders at Monash University, and also Michael Haralambis, who I think is here somewhere, from the Centre for Innovative Justice, and his team there at the Centre for Innovative Justice at RMIT, and the Voices for Justice group through the Enabling Justice program, the consumers in that group. So I've been on a journey with them to learn about how we can maybe improve our court processes. And I wanted to start off with a story, and it's a story from my everyday work. So I work in Dandenong Court, southeastern suburbs of Melbourne, about 20,000 criminal cases, 6 magistrates, 6 judges deal with in a year. So it's a very busy mainstream court in the outer suburbs. And I want to tell a story of a man called Joel. Now, Joel is a man with lived experience of acquired brain injury, and he was charged with criminal damage. He broke a glass door at the Centrelink office after his benefits were cut off because he'd missed too many appointments. He attends court for the criminal damage charge. He walks in and he goes into the courtroom and he sits there alone waiting for his case. Now, he's anxious, as the last time he came to court, the judge said if he offends again, you'll be going to jail. And he remembers that, and he becomes increasingly agitated as the day drags on. The court breaks for lunch. He still hasn't been called, and he's hungry. He couldn't eat breakfast this morning because he was running late, and so he's hungry, but he doesn't have any money for lunch because his Centrelink benefits have been cut off. But he's got some bread at home that the Salvation Army had given him, and so he's had it at this point, and he wants to go home, get something to eat, because at least he's got the bread there and he can eat something, and he's over this court business. So he's embarrassed about not having money, he's embarrassed about the whole situation, and he doesn't tell anyone he's leaving court. And he doesn't go into court that afternoon when his name's called and a warrant's issued for his arrest. A few weeks later, at 6 a.m. in the morning, as police do, they bang on the door of his rooming house, and he freaks out, to use his words, because the landlord has told him that if there's any trouble, he's out in the street. And he's only just got that accommodation after being homeless for many, many months. So he's freaked out, he's struggling with the police, and he's swinging his arms around as they're trying to arrest him. And he accidentally hits one of the officers. He's arrested, taken to the police station and charged with assaulting a police officer. He has prior convictions for minor assaults, and he's got a warrant because he didn't go to court, so the police remand him in jail. And eventually he's taken off to the courthouse, and he sees a lawyer for a few minutes in the cells, and the lawyer speaks really fast and says a lot of different things at once. And Joel doesn't get everything that's being said, but he gets the bit, if he pleads guilty, he'll get out of there. So he gets that bit, and he's taken before the magistrate in the courtroom, and everything the police say he's done is read out, and he doesn't agree with it. There's bits he doesn't agree with. He's getting stressed. He's shifting in his seat, and a few times he interrupts, and the magistrate says, be quiet, I'll have you taken back to the cells. It's not me, of course, I wouldn't say that. His lawyer tells the magistrate, that Joel lives at the rooming house, that he's not working, that he has an anger management problem, nothing about an acquired brain injury, because his lawyer didn't ask him anything about that. His lawyer asked Joel to be released on a community corrections order, a probation order in the community, but the magistrate disagrees, noting that Joel has failed to comply with 3 community-based orders before, and so Joel is sentenced to 3 months jail. Now Joel's very worried because he's definitely going to lose his housing and he'll be homeless all over again. So that's Joel's story from a number of different cases I've heard over the years. What do we know about people with acquired brain injury in the criminal courts? Well, we know there's a high prevalence. We know that they have poor justice outcomes. So, there's fines. Fines are useless, aren't they? fines, then you have community corrections orders. They're not given any reasonable accommodation in those community corrections orders. They're not given any extra support. They can't do them, and then end up just sliding inevitably into jail often. The other thing we know is that there's intersecting and compounding factors. So it's not just one thing that leads to offending. It's a whole lot of, we heard this morning about the dynamic risk factors that are present. You know, the homelessness, the social exclusion, the substance abuse, the lack of supports, all these different things that intersect. So there's not just one easy lever we can pull to solve this problem. And I think this was well encapsulated by Eileen Baldry and her colleagues in a 2013 study where they were looking at people with cognitive impairment generally, but talked about that people in that situation are often funnelled into agencies of control rather than services of support that they need. And so that's what we see happening. You see with Joel, you know, he's got a situation with Centrelink that's a very real situation. His benefits have been cut off. He breaks a window. He ends up in court. He doesn't stay at court. He ends up being remanded with the police. He ends up being jailed. You can see just the control that's just, and none of that time he's been provided with any appropriate support. The other thing that we know is that courts are only one part of the story. So, you know, I'm going to talk about my little bit, but there's a whole other service system out there that we need to fix as well. Sometimes the ambulance is at the bottom of the cliff, but we need to do better, definitely. Now, in Victoria, for those of you who know, and there might be some people here, we have some very good examples of great practice. Okay, so pockets of wonderful practice. So we have a court support program called KISS, which is available in our mainstream court, which does do some work with people with lived experience of acquired brain injury. And we have a fantastic specialist approach, the Assessment and Referral Court, ARC, which is a mental impairment court that does amazing work with people with lived experience of acquired brain injury. That is only available in certain locations, so it depends where you are. So I'm not satisfied with that, and neither are a lot of people in our court. So we're starting to talk about how can we change courts completely. So let's just go for an easy thing to do, just change the whole system, why don't we? So how do we think about that? Well, we want to have an underlying philosophy which underpins everything we do, and that's what we call our therapeutic jurisprudence approach. It's a huge mouthful, but we just say TJ, that's easy. It also sounds a bit cool. Now I'm sounding like a stupid older person, but anyway. A TJ approach. So has anyone heard of TJ before? Few people up the back, well, great. So a TJ approach, traditionally, you know, you have the law over here and you have all you other wonderful social scientists and medical people over here, and the lawyers think they know everything, yeah, but they don't. So what TJ does, it's an approach to the law that says, hey lawyers, legal system, you don't know everything. Actually, there's all these people over here who know stuff in the social sciences. So why don't you link up with them and see what they have to say about people with lived experience of acquired brain injury and what people with lived experience of acquired brain injury actually think and know from their own experiences, and how can we use that to actually change the law. So that's as simple as it is, TJ. Sometimes people say, oh, this TJ approach is really soft on crime and blah, blah, blah. It's not. It's still the same law. It's just if you're dealing with someone who has a particular need, you actually draw from the social sciences so you actually know what you're doing. There's some underpinning TJ values, and they are values of human dignity and self-determination. So that's at the core of TJ work. Human dignity, self-determination, autonomy, choice, voice, all those great concepts that we know are important, essential to recovery. And then also, I'm going to throw into our TJ framework the human rights discourse, because it really does marry up. So the United Nations, not national, Convention on the Rights of People with Disabilities, there's those talk about human dignity, about choice, about self-determination. Those concepts are very real in that discourse. So my thought is that a therapeutic jurisprudence approach that incorporates human rights has the potential to shift courts from being ineffectual and harmful agencies of control to more just and more effective agencies of dignity. So changing our courts completely. So how do we do that? Well, I want to talk about some broad principles because I want to just not talk about Victoria. I want to talk about how this could be applied across the country and around the world as well. So the first thing is that we can't just look at, okay, there's people with lived experience of ABI coming to the court, we need to provide something extra for them. We need a safety net of good practice for everyone. There's so many people with so many different disability. There's so many people who's, have language, English is not their first language. There's people who have learning disabilities. There's all sorts of people coming before our courts. The law is confusing enough for me. I'm often confused. Let alone anyone coming before the court. We need to have good practice for everyone so that the process is good for everyone. And that's what we call that universal design. So that's at the heart of, you all know this of course, that you design systems for everyone to be able to participate equally rather than saying, oh, I've got a disability so therefore you need to do something extra for me. And so that the moment you walk in the door, you're being, the service that's being provided assists you. And the other key issue there is human-centred design, so where we're looking at the lived experience of people with disability and actually having them inform our court reform. Then I'm going to talk about a few key principles here. Dignity and self-determination are our values. We need awareness and knowledge of disability and its impacts across the system. So that's the training issue. Everyone from the security person at the front through to the magistrate. Everyone along that pathway needs to be aware and have training. All interactions, again, from the security onwards, need to be procedurally just, so giving people voice and trust and respect, and trauma-informed. So those trauma-informed principles need to be applied across the board. All persons need to have access to judges who apply solution-focused judging, so not just those who are lucky enough to get into the specialist court, but every mainstream court needs to have access to that approach. And of course, for Aboriginal and or Torres Strait Islander people, we need to have self-determination so that those organisations and practices are at the heart of what we do, and also intersectionality is considered and acted upon at all points. So they're the kind of broad court reform principles we need to reform our court. And then we need to have the right intervention at the right time for people with acquired brain injury. So I'm talking here about recognition, so having ways of recognising people in the system so that they feel safe to disclose, that there is simple screening and assessment at key points, that we triage and identify their needs and link them with the right level of support. Can Joel be dealt with in the mainstream court by just a few extra services, or does he need a more specialist response in our assessment and referral court where it's more intense? And all the way through, people need to be provided with proper legal support and non-legal advocacy at all stages. So if we think about Joel and what that means for him, so Joel comes in that day and he's pretty nervous and he walks in, and the security people are fantastic. They can see Joel's a bit nervous and they talk to him in a respectful way. They link him up with a court network volunteer who gets him to the right court and who says, he goes to the front desk to let them know he's there, and they ask a simple question. We want to make sure today, Joel, that you get the best service we can give you at court. Do you have any support needs that we need to know about today that would help us help you? Joel might feel comfortable at that point to disclose his ABI, and then it could be, well, okay, so given that we don't want you waiting around long because that's going to make you, that uncertainty is going to be difficult for you, so we'll give your case some priority. A non-legal advocate gets assigned, so someone who can sit with him and talk with him about what's happening until the lawyer sees him. If the lawyer sees him, the lawyer's trained in in acquired brain injury knows how to have the communication. The lawyer identifies that Joel discloses the acquired brain injury and says he needs some support with Centrelink and other needs. And so the court support triage worker comes along and talks to Joel about what he needs. They come up with a support plan and think, well, okay, Joel's happy to stay in the mainstream court. He could go to the specialist art court, but he maybe doesn't need to. So he could be in the mainstream courts, but we'll present this plan to the judge, and then the judge gets that, and then Joel is put on that plan, maybe before that judge coming back without the need for community corrections to be involved, or if it does need community corrections involved, that information's all passed on to community corrections and then they work in a way that's appropriate with him. That's another story, we'll have to fix that system too. But so you can see a very different, just in that short court interaction, a very different response to Joel. So we've just got a little bit of work to do on that, but that's the idea. Thank you.
So much for I'm just a lawyer, I don't know much. Judge Eugene Hyman is a retired judge of the Superior Court for the State of California, County of Santa Clara, where he presided over cases in the criminal, civil, family, juvenile and probate divisions of the court for 20 years before his retirement. Please welcome Eugene.
Thank you very much. Judge Spencer is a very, very tough act to follow. I'll do my best. Let's see if I'm going to pass PowerPoint. Let's see here. Does this mean that my petition for entry into the country is going to be denied? All right.
The solution is at hand.
Well, sorry, mate. Yeah, well, there's always someone. All right. No. That's it. No. Yes, that's it.
Perfect.
Yeah. Okay, thank you. All right. Location, location, location. No, I'm not selling real estate. But it is about location, 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 because location is the location of the brain, which is going to affect, to a certain extent, the difficulties that the person's going to have. Location, what state are you in? And first of all, I adopt everything that my colleague had to say, because in an ideal world in the United States, everything she said would be terrific. I'm not here to be negative, but I'm here to talk about the reality of what justice looks like to a certain extent in the United States. And to a certain extent, it's all about the money. And to a certain extent, it's all about how do you get money. And to a certain extent, it's all about how do you get therapeutic jurisprudence. And to a certain extent, because if you look at the jurisprudence courts that we have, drug treatment court, veterans court, all of our therapeutic jurisprudence courts, they're based upon saving money, which usually means that we save prison beds or county jail beds. That's how they're justified. Because we're going to have problems in the United States convincing our politicians to give us resources for acquired brain injury when we don't save money, because they're going to say, wait a second, we're not giving sufficient resources to those people who are not in the criminal justice system to have acquired brain injuries, and they need the resources. Why should we be giving it to people that are in the criminal justice system? So that's the argument that we have to deal with, those of us that are in the criminal justice system and want to be providing. So when we talk about the consequences, the more serious the injury, the more problems the judge is going to have with respect to resources. Because the more likely the serious the crime, the more likely the person is going to go to what we call a state prison. The more likely to go to state prison, number one, I, the judge, lose any possibility of trying to create a plan for you. You're going to the state prison, you're going to be going for years, they're going to be taking control over you. I have no say whatsoever. When we talk about rehabilitation, rehabilitation takes place at the local level. That's where the collaborations are. That's where we have the community colleges, that's where we have adult ed, that's where we have all kinds of people that are willing to work together to try and come up with programs. How do we deal with the programs? It is people that are willing to dedicate, agencies that are willing to dedicate people to help the court with respect to giving resources. Keep lots of statistics in terms of the people that you're serving, and they're able to get more resources for what they're doing. That's ultimately how we do it. What is our largest mental health institution in the United States? County jails and state prisons. I mean, when you wind up in a state institution, what's the mental health resource you get? Medication. You're not getting a lot of counseling at the state level. You're getting a little bit more at the county level, and you're getting a lot more if the person's giving community release and they're out into the community. So not only is the crime important, that is it an indictable or is it summary? If it's summary, then you're going to be doing maybe some time locally and then more on release. If it's indictable, you might get some community release, some local, and then the possibility of going to the state. So then we're talking about training judges, training correctional officers, training police officers, training prosecutors, training defense attorneys. And it starts with the arresting police officer. The arresting police officer brings the person to the county jail, needs to identify the person as having a brain problem to the correctional person that they book in, and that saves time. Otherwise, it's going to be days before this person's identified as having a brain injury. And it's just a slow process. The police officer may not really have a great deal of sympathy. You know, if the person with the brain injury has committed a property crime, great, a lot of possibilities. The person's committed a drug offense, a lot of possibilities. A lot of the people with brain injury have co-occurring problems, usually substance abuse, low-level crime, low-level maybe violence. If we're talking about serious violence, then my discretion is going to be tied. A lot of mandatory sentencing. When you start getting mandatory sentencing, I have less and less options. Resources, what resources? Well, the same thing as Judge Spencer. I mean, we have limited resources. We have to hobble them together with chewing gum and string. And that's what judges do. Judges are leaders. Judges that care are leaders. So what kind of a judge do you have? Do you have someone that wants to create, or do you have someone that just wants to move cases? And you know, hopefully, people that are doing these collaborative courts are people that want to be there. There's nothing worse than a chief judge or a supervising judge that assigns someone to one of these courts and they don't want to be there. You know, there was a vacancy and then round hole, square peg, and this is what happened. It doesn't work. The people that go into these assignments, lawyers, correctional people, everyone has to be a person that wants to do the assignment. If they don't, it isn't going to work, and it's going to be really, really sad. And prosecutors have so much power because the prosecutor can charge the case in such a way to make a person ineligible for these therapeutic courts and these therapeutic programs. They can make a case a certain kind of indictable, the person won't be eligible, because all these things are sit-down contracts where everything is negotiated in terms of who's eligible for these programs. And that's how these drug courts started out, and certain kinds of people were ineligible based upon records and based upon crimes and based upon these kinds of things. And over the years, they've expanded who was eligible for these kinds of things. So it's been, the number of cases in the United States where the acquired brain injury people is just beginning in terms of, number one, the recognition, the identification, and how we're going to treat them. The protocols in terms of the interventions are just beginning. I mean, this is relatively new ground for us, certainly in the States. I mean, we certainly know about it. The research is certainly clear. But I think Australia, certainly in Victoria, you're way ahead of us in terms of the resources. It's the collaboration in terms of the availability. They're based upon the willingness of people to participate, and sometimes they're willing and sometimes they're not. And again, they're based upon the seriousness of the crime is going to dictate in terms of how driven people are in terms of trying to help. With respect to drugs, we recognize now, that we've recognized for quite some time actually, that people with substance abuse issues, it's an illness. We haven't quite accepted with respect to criminals with brain injuries that some of them are not, well, they're not responsible for having the brain injury. Where we haven't gone yet is that people with certain kinds of brain injuries are not necessarily responsible for what they're doing since they have the brain injury. And that's sort of part of the problem. They have the brain injury, which is a mitigating factor, but they're not so mitigated that they're not, they don't qualify for incompetent, criminal incompetency based upon their injury. And as a result, they're still responsible for their behavior. I've already covered this. Record keeping is critical because you have to demonstrate how many people you've helped, not just the court, but you also have to record keep for the agencies. That's how they get more funding. In terms of, here's the irony, in terms of the agencies are usually the local government agencies. The court is usually the state, and the county gets money sometimes from the county. They also get sometimes money from the state, and they sometimes get money from the federal government. So depending upon what their funding stream is, if they're calling it supporting brain injury, as long as they don't call it that they're getting that they're supporting brain injury people that are in the criminal justice system, then that might be okay. The second they say, hey, we're supporting people in the criminal justice system, that might be problematic because, as I said, the politicians just aren't sympathetic. Give up hope, all thee who enter here. Well, we have a state system, we have a federal system, and our federal system has the least amount of resources. And, you know, we have, well, you've been hearing about our federal government. And the public, unfortunately, is the least interested in the welfare of those people that are in custody. They're not sympathetic. They just are not sympathetic. I mean, look at what happens. You know, we have Rikers Island, which is a huge local custody place in New York City, where horrible things happen in terms of assaults, sexual assaults, beatings, murders in New York City, and they've been trying to close that for years. And the average citizen is just not concerned. Hey, you know, don't commit a crime, you won't go there. That's the attitude. And that's not particularly helpful. And I think in terms of having hope, because I think we have to have hope in terms of our world, and I think this conference is about hope, incremental hope, is that we have to view in terms of the path we take based upon what my colleague was talking about in terms of doing things a little bit at a time. But in terms of the resources, we don't have someone that's going to hold someone's hand in terms of helping them through the process. And most of these people as they visit us in the court system, the odds are they're going to be in custody. Because a lot of them are going to have prior convictions, and a lot of them are going to be facing serious criminal consequences, and as a result, they're not going to be able to make bail, and they're going to be felt to be a serious risk in terms of a written promise to appear. And I've covered what I needed to, and thank you very much.
Molly Towns O'Brien is an associate professor at the Australian National University College of Law, where she teaches evidence, litigation, dispute management and human rights. She has also written and made presentations relating to her recovery from a severe traumatic brain injury she sustained due to a bicycle accident in 2013. Please welcome Molly.
Looks good.
Here it is.
Yeah. I'm talking about representing the brain-injured accused. So if we talk about location, 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 I'm at the location that's before those guys. And I think once you get into court, it may actually be too late. And even the defense attorney's location is too damn late. We really need to be focused on those early interventions, like when a woman is pregnant or being abused by a partner, or when you've just had a brain injury, or some other early time. When you represent someone who is accused of a crime, the stakes are really high. And this is what I tell my students when I was teaching criminal law. We would have simulations in class, and I'd say, you know what the best thing about this is? At the end of this, nobody's gonna go to jail. That used to make me feel really happy. And it doesn't seem to have that effect on the students, though. But a traumatic brain injury survivor may not be recognizable as a person who has a traumatic brain injury. This is a photo that I got from the web, and apparently this guy has a traumatic brain injury. And I think there are more things on. The brain injury may never have been diagnosed, or the person may be unaware of the brain injury, or they may be too proud to talk about it, or like Jay, you remember Jay from the movie, who waltzed through the first 7 years of his recovery? He wasn't talking about his brain injury. He wasn't thinking about it. He was just trying to do his life. And people with traumatic brain injuries may be just trying to live their lives. And the person with the traumatic brain injury may act like someone who hasn't had a traumatic brain injury. And when I heard Jay say that in the movie, I thought, that was me. I went back to work. I was teaching law, and there was nothing wrong with me. And it was only when I started looking at what I had been doing, and when I started receiving evaluations from the students, I got 17 in my first semester back, 17 students who said, she's a good teacher, but why does she speak so slowly? Speak so slowly? I thought, I don't speak now. I thought, I don't speak slowly. So I started drinking coffee. And people with traumatic brain injuries are not likely, when they're accused of a crime or when they're in a difficult situation, it may not be the first thing that they bring up. And they may not think it has anything to do with the crime itself. And they may not remember committing the crime, or they may not have insight into the situation, or it may be all scrambled up in their heads. And that is also symptomatic. I mean, irritability and being aggressive, those are things that are common when you've had a brain injury. But it may also be common that you don't have insight and memory of what you've been doing. And so the people around the brain injured person, oh, this hasn't come up for you. The people around you, if you are the brain injured person, you need to be like mirrors for the brain injured person. I was paralyzed on my left at first. And when I was trying to come back, I would be doing physical therapy, and I'd have two weights, and I'd lift them. And my husband would say, lift the left. And I'd say, I did, I lifted it, didn't I? And he'd say, actually, he bought a mirror, a 6-foot mirror, and put it in the living room. And I go, oh, now I see what you're talking about. And I was able to lift it, but I didn't know I wasn't lifting it. I mean, I would stand there like this and I'd say, it's lifted. And he couldn't be the mirror because his telling me did not convince me. It was only seeing it that convinced me. Anyway, so if you have a brain injury, you may have available the defense of mental impairment. And what is that? Well, when an accused is under a mental impairment, this is the statute that applies in the ACT where I live. You need to know whether the accused did not know the nature and quality of the conduct and whether the accused knew the conduct was wrong, and whether the accused could not control the conduct. So there is a recent case, this is Hoyle and the Queen, and in this case a defendant, this is actually Hoyle. I couldn't help but put the actual guy up there. I figured, well, we want to see who this Hoyle is. He was a 65-year-old business law lecturer at University of Canberra. So it sounds pretty respectable. And he was found guilty of 8 sexual offenses against 5 female international students. And they were all of them were Chinese, I think. And he brought them into his office and he accused them of plagiarism, and probably they did commit plagiarism. That was not on trial, but what was on trial was that he would let them off if they gave him sexual favors. And I think he took some sexual favors, whether they gave it or not. And there was a verdict of guilty against him on all of these charges, and his lawyers had him medically examined before the sentencing. So it had been found that he had done the offenses, but what was going to happen was he was going to be sentenced for those offenses. And when he was examined by physicians, this is after a whole trial has gone forward, they found out that he had had a found here. But for the court, the fresh evidence, they said the fresh evidence does not support the proposition that Hoyle did not know the nature and quality of his conduct. So we're talking about a guy with a neurodegenerative disease and a brain injury and no ability to recognize social cues. For the appeals court, it wasn't enough to establish that he didn't know the nature and quality of his conduct. And the appeals court pointed out that he had prepared a PowerPoint presentation to give to the Chinese students showing pornography, and that was for one of the students, and they said on that basis the appeals court could conclude that his conduct was premeditated. So it wasn't spontaneous. He was planning this out. And there were eight students, so, you know, they figured he must have known. If he didn't know the first time, he knew by the sixth or seventh time. So here was a guy with a traumatic brain injury and a neurodegenerative process and medical evidence, but he had been found factually guilty, and the court said, so we really don't care what happens to you. Now, I'll tell you that for a defense attorney, the task of representing a brain-injured person may be difficult because the accused may not know or accept that they did the offense. And there's a term, Animus Ignazio, where people, I don't know if I pronounced that correctly, close enough? Nick says so. Really, it is likely that people who have brain injuries have no insight into their brain injury and no insight into their conduct. So they don't know, and they deny that they have a problem. If they do know that they did it, they may not have been able to control what they did. And impulsivity and irritability are other symptoms that last of brain injury. So the defendant's lawyer may not have understood or accepted, may not have known or understood about the client's brain injury, and even if they did know, there may not have been time or the ability or the money to make plans to get those medical examinations done before the trial. And this situation, if it's difficult for the attorney, it is even more difficult for the brain-injured client, because the client may not remember or have insight and may not be able to help in their own defense and may not be able to work to rehabilitate themselves. And we've talked about today, other people have talked about the high number of brain-injured people who are in prison. And as far as I know, there are no programs in the ACT prison to help brain-injured people. There are no rehabilitation programs. There are no meditation programs or education programs. In fact, I don't believe the ACT prison even knows the number of prisoners who are illiterate. They don't even know. If they don't know who can read, how do they know who's got a brain injury? You know, it makes you think. Now, where's Sharon? Raise your hand. Okay, there, Sharon. You work with a program in some other state.
Library program, and I used to work with independent third-person program as well. And the library offer people programs to go into.
Okay, so there are some programs in some states, but I'm telling you, I think the location is too late. And what we really need is a new appreciation of acquired and more diagnosis for acquired brain injury. We need more accessible rehabilitation programs, including programs in prisons, and we need more discussion and evaluation of the defendant's condition before trial. By the time you get to those guys, you've already waited too late, because the ability to actually undertake corrective steps and rehabilitation is early. And we also need better expert evidence and better legal standards. And so that's way away from those guys. They set some standards, but we need legislation that fits traumatic brain injury patients and their situations. And I'll leave the questions and discussion for your